You think people are like not going to because
this
you're
has been
coming on later?
The whole beginning of this show has been a total shit show. It's been bad.
No, Michael,
it's been really bad. I mean,
it's called a tease. It's called a tease. They always do that on the news and other things. Says this next story's coming up. So I just want to tell people there will be an appellate update. Later in this show.
Alan, you basically
he just did it twice right in front of you.
You have this view
so
of the
that you
show
would
as
understand
like
it better.
Like, it's like going to like the Bruce Springsteen concert, and there's like 4 openers who aren't really that important,
right?
And you're the Bruce Springsteen.
Well,
it's kind of what I
just want to make sure that they.
It was kind of
right.
It was a slow build up.
Joining us is Amanda. Amanda's appeared again, and she's despite what goes on here, she came back for more. I don't know why, but just thank you for being here.
Glad to be here. Glad to be here.
Very good. In the back there, where there's a lot of talk about driveways and things like that, it's our dear friend, the component of it all, the center of the neutron and the atoms that spin around here at Cornwall. Please welcome. Steve Miller.
All right.
Commander.
Good to be here finally for a week.
Himself.
I don't have to supervise off-site by phone, so it's good to be here. It's going to be a great show. Like Alan said, we got a good appellate update coming. It's going to be a good one tonight.
That's 3 teases.
And I don't know, maybe Butters will have something for us. Let's say Butters.
I bet not.
I might.
When Steve's not here, he's busy winning hockey championships with his kid giving promotion.
I want to understand this Butters.
I'm afraid to ask, but I do want to know.
Explain it really quickly.
Yes.
Not yet.
Yeah.
No.
No.
Does it have to do with the top of his head?
No.
No, but at the top of his head, Charmy.
Wait. Can you explain what that means?
It's smooth like butter.
There you go, like butter. Yeah.
We'll just go with that.
All right. I think we're
That's
gonna.
what I thought.
I think it would be probably best that we take a quick.
Yeah, let's finish the whatever we're doing.
We'll get through.
I think we got through it. Didn't we? No.
Jeff Frazier.
Jeff Frazier
has not been introduced. Please welcome Jeff Frazier.
Hello.
And of course, Butters over here, Josh, who's sitting next to me. I don't know why. I'm just playing along now because the takeover has been so powerful. I've just capitulated to whatever's going on here. Can't keep it straight.
Steve's gonna will it into existence. Like he's literally out there. He made a song about Butters.
No, he didn't.
Which is available on
Give
iTunes.
Jeff a guitar.
It may
We're
or
about
may
to
not
hear the
come
song.
from the fact that Josh likes to eat fried butter at the carnivals.
Ooh.
Fried butter.
Fried butter, fried Twinkies.
What is fried butter?
Elephant ears.
Oh, fried elephant ears. Yeah.
Elephant ears, yeah.
You can't fry butter.
Yeah.
All right.
Fried
And
Oreos.
I think
all right,
I think we got the
we need to
intros.
regroup.
Those
We need to get everybody.
I'm
on.
ready to rant. What are you talking about?
Okay, well, I'm going to shut everybody's mics off.
Yeah, there you go. Mute everybody so
Where did
Michael can rant in peace.
Oh, never mind.
Chad, you say that with such lack of tension.
Come on, listen, everybody listen.
There's a lot of pressure in this right.
All right, Michael, let's go.
There's no okay.
You're kind of like boxed in over there too.
So there's always so much to talk about, and I want to get right to it. This is something that Chad is trying to point out. I don't know if it's important or not, but there was and Alan, of course, is going to talk about this in the appellate update. But as the Joel Selman case was decided, he's a listener to Planet Green Trees. He's called in a few times. I think he was like mad at us. We weren't taking his calls at some point because he wanted me to explain to him why the decision was, and it was just bad judging. But he's subsequently passed, making a longer list of individuals who have been killed while litigating cases in Oakland County. The list began with, I think, Torrey, Bob Redden's better half, Sal Agro after that. Brian Vaughn was another individual, and now Joel Selman, all at the hands of I think it's Jessica Cooper in the Oakland County Sheriff's Department. I do remember saying something to Judge McMillan, who we're going to appear in front of. Never mind. All right, so
People that they saw were people in the judicial system. No, Mike.
Judge, that's good. I'd like to be able to do that.
Some of the last people that they saw were people in the judicial system.
Okay. So I wanted to explain. We were going to go right into some conversation about this new awakening of one of the candidates for the Attorney General, but I'm going to rant for a second about the events that happened this last week. Me and the Fisher battle, which has become known and titled as the Rumble in Isabella, where for a long time we litigated that case, and there's a long blog about it on the MMA with color pictures, actually. And it was long, hard-fought battle. The story goes that there's, like, I filed 19 or 20 motions, and every single one of them the judge did not accept. Finally, at the end, he granted the Section 8 affirmative defense, granting and dismissing all of the charges, which was the right decision to make. And ultimately, the prosecutor appealed to the Court of Appeals, and all this other crazy things happened, which manifested itself into me describing these events as like the government acting really crazy, that the forfeiture and the losing and the changing of the laws of medical marijuana have put them in a position where they're actually acting completely bizarre. And while the appeal was taking place on the criminal case to the Court of Appeals, the formerly stayed or timeout called on the forfeiture case was reinstated, and the prosecutor, having no ability to defend the forfeiture case at all, filed a motion to recuse the trial judge. So let me make sure it's clear. We had a criminal case in front of Judge Chamberlain. At the same time, there's a forfeiture case as it goes. The forfeiture case was put on a stay, with the parties agreed to a stay, like calling a timeout. It's not going to happen. We're going to litigate the criminal case. We litigated the criminal case, and it resulted in dismissal of all the charges because of Section 8. Section 8 says if you prove prongs 1, 2, and 3, or A, B, and C, there shall be no forfeiture. So after that ruling, I brought that law with me to the forfeiture case, which had been, the timeout had been called time in, the stay was undone. We appeared there, and it should follow that we would win. What the prosecutor said was, I have nothing to argue. My case that I lost in the criminal case is now on appeal, and if you, judge, won't stay the forfeiture again, I've got nothing to argue, except I move to recuse you because 17 years ago you made a negative comment about forfeiture and how you thought it was double dipping. I'm not complaining about how in the last 17 years you ruled in my favor about forfeiture, but I'm going to complain about something from 17 years ago. And as it goes, this is the chief judge, so just delayed things more. After that judge said, no, sorry, that's not a grounds for me to recuse myself, we appealed, went to another judge. That judge said, are you kidding me? This is ridiculous. They sent it back down. And the judge granted our motion to dismiss the forfeiture, ordering all of the property to be returned, all of it. And as we were making our arrangements to go there and pick it up, Steve Miller, of course, leading that operation, they told us they're not returning all the stuff. What do you mean? What part about the judge's order did you not understand? Return this, 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 and this. Well, they decided that despite the court's order, they're going to keep it. Certain things, because even though the court told them not to and they have no legal basis to, they're going to do it anyways. And this wasn't even the issue at hand. But that motion, that issue, which is a motion accusing the prosecutor's office of violating the law, what they call a show cause, was scheduled a week ago, last Friday. We drove up there, me and Dewey. Steve was with us in the car. So we pulled in the parking lot. Dewey like a hunter. Like a hunter. He does spot deer from everywhere. It's crazy. He's like, oh, did you see those 12 deer over there? Like, what deer? What are you talking about? Look at those helicopters up there. What's going on with those helicopters? Look, so what's going on? So sure enough, there's a shooting at Central Michigan University, right? The joke was that it was the prosecutor who I'm up there accusing of, of violating the law. It was him seen running to distract us. Meanwhile, the court was shut down. Shut the court down because of this shooting over there, and we had to reload on that. We still don't have a date yet. But this past Tuesday was the Court of Appeals argument on the criminal case, where they had appealed the decision of the judge for Section 8, not just to give us a right to present it to the jury, but in fact the right to, just the all-right dismissal. So that's what we were doing before the Court of Appeals. Alan Peisner was of great assistance to getting my head in the right spot, as was Jeff and Josh a little bit. Chad, of course, was able to be there for me to distract me and force me to focus harder and not be whatever. But the arguments, I'm going to take a second there. For those that love the Section 8 and all of its glory, 3 issues. One is the bona fide doctor relationship. 2 is the amount, not more than an amount of marijuana reasonably necessary to supply the patient's serious debilitating condition. The third one being that the cannabis at issue is for the patient's medical treatment of their debilitating condition. At the end of the day, standard says if you present prima facie evidence in each of the 3 prongs and no question of fact exists, it should be submitted to you should get a dismissal. If question of facts exists, it would be submitted to the jury. And if you've failed to present some evidence towards one of the 3 prongs, then you lose. And do not get to present the defense or get a dismissal. So the trial court had ruled in our favor that each of the 3 prongs had been established by prima facie evidence and no questions of fact existed. In other words, if they sent it to the jury, the judge said it was so clear from this hearing, this testimony that took place, that none of the jurors could disagree with what I believe is that they would find you not guilty, in other words. So what could this prosecutor argue about? And when you get to the Court of Appeals, they give great deference to the fact finding of the trial court usually. The judge there, they weigh and look and see what's going on. They're not going to undo that usually. Usually they're going to reverse if there's some grave legal error. So the prosecutor started up with the bona fide doctor-patient relationship, and he was shut down. It's kind of interesting. Usually that's one of the most attacked and issues, and I'm not saying that I'm discouraging people from being mindful of that, but it was not something they took great interest in. And ultimately, there was a tendency to want to say that the amount of marijuana should have been submitted to the jury. In this particular case, they alleged 30 pounds of marijuana, and that should have been submitted to the jury. That's what they're saying. But my argument was, if anyone's listening, was their best argument is that, yes, but all they're saying is 30 pounds of marijuana. It's way too much marijuana. 30 pounds of marijuana. It's too much marijuana. But that's not the issue. It's not because they're saying 30 pounds of marijuana and we're supposed to believe that 30 pounds of marijuana is a lot of marijuana. It's whether or not it was an amount reasonably, not more than an amount reasonably necessary to treat their debilitating conditions. My clients got on the stand and told their medical necessity story, which involved 10 of the pounds or 8 of the pounds being total garbage that needed to be discarded, and the remainder of it that they were ingesting between the two of them somewhere between 4 and 5 grams of oil a day, which required 4 or 5 pounds a month. And when you get to that amount, they didn't have nearly enough, as the court found. Now, why would there be a question of fact about this? Who would think otherwise? Who could tell a story differently? Certainly not the police. The police have never and do not comprehend, nor have they been trained in any way, shape, or form to be able to rebut that. They know that looks like, smells like trafficking in their training experience. That's all they know. But they don't know anything about medical marijuana, and they can't rebut that. So it's not a question of fact, I think, is what we believe, and I think we argued to the Court of Appeals, and I guess, as they say, we shall see where they come down on that issue. But that's why we were there this week, and I don't know if that made any sense. But all right, so that was kind of a rant. I don't know if I feel any better, but let's take a break, regroup. I know Jim Powers wants to. Is he still in here? Oh, yeah. Okay.
I'm here. I'm very concerned that the structure that we've fought so hard for is just crumbling in our hands.
That's how it goes. I mean,
I know.
I feel my pain these days, right?
I know, it's horrible. It's really bad, but let's go to a break, and we'll figure it out.
All right. Good segment.
Yeah.
All right.